So this conference originated out of a meeting with TBI, AOC, CTAS, and MTAS last summer. Actually, it was Heather Duncan who kind of said, you know, wish there was like an all-things TBI conference. And then here it is. So we'll see how this goes. There's discussion of making it an annual event, but I mean, we'll just have to see how this goes. You might not want to do that. I don't know. I have a lot of thank yous. So our amazing partners at AOC, CTAS, and MTAS, we couldn't do our jobs without them. They're so helpful. We have our fantastic criminal records unit who has gone above and beyond today. I wouldn't be lost without them this morning. My manager, Kenneth Blue, who's not here, and Yasmin Pendleton, who's the assistant director. I know I saw her, but she might be in the lobby. They had faith in us to do this conference, and we'll see if we keep that. Also, the TICS unit was very helpful yesterday, setting up the tables. Whose computer is that, Matt?
Probably yours.
I don't have my sound. Okay, anyway, and so Matt with our lab side, also thank you. And then Angela from our sex offender registry, they were both instrumental. I would not be standing here right now without them. And also the training unit. This has been very helpful. So we're going to just go through some quick introductions. We're not going to specifically introduce people until their session. So right now, if you're with TBI, if you would just stand up so everyone can see a fairly large contingent here. If you're with the AOC, Lisa, would you stand up? Which everybody knows Lisa. And next is Heather with CTAS.
And a couple of CTAS friends.
Okay, all the CTAS people. Thanks for coming. And MTAS.
Hello, John.
Department of Safety.
Okay, about.
Got in the back. And then correction. I don't know if Lori's here yet, but correction. Yay. Okay, so now here's where the rubber's going to meet the road. And Matt is going to see if I remembered what he told me to do. Uh-oh, where'd my folder go? Oh, wrong computer. Hello. Nice. Getting a little, oh, there it is. Okay. So here's a welcome from Director Roush.
Hello and welcome. I'm David Roush. I have the honor of serving as the director of the Tennessee Bureau of Investigation. And I want to welcome you to TBI for this mini conference to have a discussion about how we can work together with the information that you have and the critical nature of the work that we do here at TBI. And so we are excited that you are here with us and we know that you will have a great time while you're here learning and understanding how we can work together in sharing critical information that the courts hold in order for all of us to be able to keep Tennesseans safe. And so thank you for being here. I apologize that I can't be there in person, but I hope you understand that we really are appreciative of our partnership. Thank you and have a great conference.
Okay, so first up, we have Maggie Henneke with the drug registry. So Maggie, if people have questions, can they just ask them, or do you want them to hold them to the end, or?
I think the last slide says question.
The curve.
Okay. Good morning. How are y'all? Morning. Okay, so as she said, my name is Maggie. I'm maintaining the drug offender registry. It was originally titled as the Meth Offender Registry and was created in 2014. It is a database that lists the conviction charges of anyone that's been convicted of a meth charge, but then it was created in 2005. It changed to just the drug offender in 2014. So now it's any felony drug charge or a misdemeanor meth conviction gets put onto this database. So person, this on the phone. Okay, so this is the TCA code. Okay, so the drug offender registry contains the name of the offender, their date of birth, their social, their driver's license, as well as the county that they were convicted in, and then all of the conviction offense. So the original offense, then the arrest date, and then what ultimately they were convicted of. So if it is the same offense or if it is a lesser offense, it is listed on there. And they are required to stay on this registry for 10 years. At that point, we remove them. The 10 years starts from the sentencing date. So an example would be if you were sentenced in today, so December 10th, 2024, say you were convicted of a drug felony charge and today you were sentenced to it. 10 years from today is when you're removed from the registry. Okay, they're also, in the event that they die, they're removed as well. Okay, so what do we need from you guys? For our purposes, we are required to retain a copy of the actual judgment in our files. So we prefer if you send us a copy of the judgment so that we have on file. However, courts do also send the AOC reports. That is beneficial to us. We do appreciate that, but it's not required. You can just send us the judgment. However, if you have the reports and you want to send it along with the judgment, that's helpful because there's a lot of information on the reports that is not listed on the judgment because there's not a ton of space on the judgment. So I totally understand that, and having the report as well. The necessary information that we need the offense date, and the drug type. A lot of times we'll get judgments that say Schedule II drugs, manufacturer, sell, possession. Well, a Schedule II drug can be cocaine, hydrocodone, oxycodone, meth. Like there's a lot of drugs that fall under Schedule II. And for the drug offender registry purposes, we have to be specific and say what it was that they had on them. Okay, so here's an example of like a report that we received. And all of the information that is on the report that we appreciate. So we'll get the violation date and the arrest date. We prefer the violation date for our purposes because that is the day the offense actually happened, and that's what we have to include on the registry. But either one is fine. So if you send us a report with this along with the judgments, it'll be golden. And then an example like the Schedule II on here, the offense originally was Schedule II, and then the amended offense was a simple possession. So for that, listed in the corner, the drug type for that would be meth. So it is a qualifying charge, and Mickey Mouse in this example would be put on the drug offender registry. Okay, as far as what type of papers we get, we have gone paperless. So we are still getting a lot of, what, is it not working? Oh my gosh. I've been going through this whole thing and it's not even on there.
12 people here.
Okay,
Where's the? Oh, I just messed up.
it's fine.
This-
You want to use this thing?
All right, and Matt is on. Yeah. Thank you. I'm so sorry.
There.
Passes.
Holly.
Yeah.
So I think we can share the screen, but what they're saying at home is they're not safe with the speaker. We confirm that they can't see the person at the podium. Yeah.
Oh,
It's just the con. So they were saying they couldn't see it. Doing that.
Yeah, if you want to share, if you're wanting to, you can do that switch for you, but they're just gonna see it.
Okay. Yeah, that's what we want. Okay. Can I get back to you?
That's fine. Where, I don't even, I think it's right here.
I thought they were saying.
Okay, no, that's fine. I was worried that like I was doing the whole presentation and nobody.
See, this is Matt, the one who I thanked earlier.
Okay. Okay. All right. We're good. Everybody can see this slide. Okay. Okay. So, we are paperless now. We're trying to get, we've updated our database to include like the judgments and everything inside one database and having it central. So we prefer if you send the paperwork to us via email. That's like the best way to send it to us. We'll also accept fax and mail stuff, but we're trying to get away from paper. So if at all possible, if you could just send them digitally, that would be fantastic. You can send the paperwork to our direct email address is tbi.drugregistry@tbi.tn.gov. And then I have also listed the mailing address and our fax number if you choose to do that as well. However, please, please, please just send them digitally. If you have any questions, please feel free to reach out. I always respond as fast as I can. I am the only one that is responsible for maintaining the drug offender registry. So there are 95 counties, so I'll get back to you guys as soon as I can. But yes, please feel free to reach out to me with any questions or comments. My office number is 615-744-4352. I've also listed my cell phone number on there, and my email address is maggie.henneke@tbi.tn.gov. Thank you. Does anybody have any questions or anything? I am done. Holly has disappeared, so I don't know who's next.
Can we go back to that slide real quick?
This one?
Yes.
Oh, thanks.
Thank you, Maggie. No questions?
I have one question about the emails. Is there any for the cities and the counties, if they email it to you, is there any risk of your encryption or privacy based upon what any sensitive information might be sent in, or is there anything like that? Because like for the driver's license may have some stuff that may need to be.
So a lot of times, when I do get things emailed to me, the driver's license and the social and whatnot will be blacked out. That's fine. We have our database as well, that we can look it up. So that's fine. If you want to encrypt it, it's totally fine. But as far as I'm aware, everything is secure that you can send it. But yes, that's totally fine. A lot of courts will email it without that stuff, like with that stuff being blacked out, and I'm able to go and find it in our law enforcement databases.
So they can just email like normal, fully unredacted.
You can redact it if you prefer, that's fine. Or you can encrypt it. As long as you send me an encryption code so that I can do it, that's fine as well.
Thanks, Maggie. So next we have Deborah Gordon with the data quality unit, who is going to talk about state control numbers.
Hello, I am the supervisor for the data quality unit. I have a staff of 6 full-time employees and 2 temps. And we process all the electronic fingerprint submissions that come in from the 95 counties in the state of Tennessee, along with the sheriff's office, and the city as well. We process applicant fee program fee applicants and law enforcement applicants, as well as the criminal fingerprint cards And most importantly, they come through mostly electronically through the APIS machine, which automatically assigns that 12-digit state control number. What we get from the courts as far as the dispositions, we want to ensure that you all are utilizing the 12-digit state control number whenever you are submitting your dispositions, because they do have to match up with the fingerprint arrest card. So that is primarily our interaction with the criminal records unit, and the dispositions is the issue with the state control numbers. Now, sometimes the courts will add on additional charges, things of that nature, and we are also the unit that process all the corrections requests. So if you're adding on additional charges, you need to reach out to that arresting agency to let them know that you're adding on these charges, and they need to send us a correction request. There's also a form that the criminal records unit provides as well to the courts for you all to fill out and forward on to the agency so that they are aware that you are adding on additional charges. I don't have any slides to present. It's just I wanted to reiterate the state control number is the primary tracking number that goes with each arrest that individuals are charged with. So if we have any questions in reference to the state control number or electronic fingerprint submissions in APIS. Thank you.
Thank you, Deborah. So Deborah didn't have any slides and the criminal records unit doesn't have any slides. We're here just to answer your questions. So for the rest of the time, do my agenda. Who has an agenda? What time does this end? 9 o'clock? 9:50. Oh, you have an hour to ask this question. Our CJIS attorney will be here. She's running late, but she will be here. But so Heather is, we're kind of co-supervisor. She says that we co-parent. So she has diversions and half of expungements, and I have half of expungements and dispositions. So we have, between us, we have 18 people plus 6 temps right now. 5 temps? 6 temps, right. So we have, who wants to go first? Don't be shy. Somebody in the chat, maybe? Oh, yes.
I got a question about the state control numbers.
Mhm.
We're having a hard time getting the sheriff's department to get them to. They have a lot of turnover in their booking, and it's been a nightmare for.
Okay, so if you'll reach out to me after, we can set up a meeting with my supervisor and your sheriff's office and the court, and I'll talk about it.
We did that. Mr. Blue come out.
Oh,
And it's still a nightmare.
okay, well then email me and let me know that so that we can get them, because you have to have that state control number to submit your dispositions. We can't do it without the state control number.
Thank you.
Oh, yes, ma'am.
I have 2 questions. When you talk about state control number, are you talking about it being in census or on the judgment?
So it needs to be, Lisa, it's in census, right? When it comes in.
You enter it on the case on census, and the TBI reporting, it won't report without that. So you'll get an error on your error report if it doesn't have the state control.
And then on the judgment, it's helpful if it's on the judgment, because the state control number marries the dispo to the arrest, and we can go right to that arrest to add the disposition if we need a judgment. However, if you're submitting through census or any other electronic way, we actually don't need you to send us any other paperwork. We just, we get them electronically. I think there's only one court now in the entire state that does not submit electronically. So that should count all of you. Any questions in the chat?
Another question.
Yes.
I'm sorry.
No, you're fine.
I think one thing we're running into is when they are adding charges,
Yes.
not, how do I say, not sealing them to get an additional arrest for those added charges.
So
How big of a problem is that?
yeah, so we have a form that we can send you, that the court submits to well, it's either the court or the DA. I mean, Every county's different, but somebody has to submit that to the arresting agency, and they can add those charges onto the original arrest. Or the easiest, cleanest way is if they just reprint them for those new charges. I know some counties have a live scan, like right in the courthouse. Some people don't. That's the easiest way, but if you can't get them to do that, then we need that form to be filled out, which somebody will make a note for me to send that out with all the other stuff. So here's why that's a problem. We had a case out of a county where the person had one especially aggravated sexual exploitation of a minor on the record. The court added 69, but there was only one on the record. So that person now has 70, by the way. We got those added on. But that's why it's important that we have everything that the person is going to be convicted of. We need to have that on the record. So if a person was convicted of that and it's not on the record, that person could potentially work at a school or some other place where they have to be fingerprinted. So it has been a tough road to do that, but we do have that form. Who's next? Oh, yes.
Do you have, if we have any questions or anything, do you have the name and phone number and email that we can call if we have any questions on these?
For expungement, for
State control numbers or anything?
yeah, you can just email the expungement email box and we can, if we need to forward it to Deborah's unit, we can do that. But most of the time we can answer the question. Oh, yes.
When we get added charges from grand jury, we do a correction and send to our jail to update the fingerprint card scan number.
Yes, and they should submit it to data quality for Deborah's team to update. That's correct. Yes.
I actually brought with me, I had an officer from the sheriff's department call me last week, and he had arrested a gentleman several years ago and knew there was a conviction. Thought there was a conviction. However, when he pulled their criminal history, it wasn't there. But our computer had several things that weren't there, but I think part of it has a state control number, but it still didn't get to the record. So I did bring it today so that we could look at, because there were several things that weren't on the record that need to be.
Yeah, so there's several things that can happen. If the person is just cited and not fingerprinted, we're not going to have it. So we don't need you to send those. But in this case, it sounds like that original charge might have just been a citation and it's guilty in your court. But if they should have been fingerprinted, they can send us the fingerprint card and we can add it to the record and then get the dispo and add that. That's our goal, is to have like what we have needs to match what the county and the city level have.
Yeah, I think they were originally arrested because they were all felony charges.
Oh, yes. So for some reason, we didn't get the fingerprint card, or maybe the prints weren't good and we rejected it. I mean, there could be like a million reasons, so.
How would we get that information if something was rejected? How would we know?
It would have gone back to the sheriff's office. And I don't really know how that works, excuse me, with the live scans.
Yeah, they would have to, the arresting agency, when they submit electronically, they have to go to their mailbox. There's an email attached to the live scan, all the responses from TBI and the FBI. That's where, and if it gets rejected, if they're checking their responses, they would have known that that fingerprint card was rejected. So that's where, how they are notified, whether it's, they get the SID number, the FBI number, or through an email response on the live scan device where they fingerprinted the subject.
But if it was before they had a live scan, it would have just been rejected back through the mail.
Yes, we would have had a reject slip on the active fingerprint card and sent back.
Yeah, so depending on how old it is, that, and how old your live scan is, that could be another thing. Okay, it's 8:57. We got a lot of time here. Hopefully when Rachel gets here, we'll have, if that's who you really want to ask questions to, is our attorney.
Like, on the sheriff department sending them too, sending their cards in too. Like they're.
They should be sending the fingerprint cards.
They are.
Ta-da!
Sorry, I was on the phone.
It's not that I pushed you right in front of me, but
And this is Rachel Russell. She's, among other things, the CJIS attorney. And she's the one that we forward your questions to when you don't know the answer. Don't want to put something in writing. But we don't have one yet.
Oh, Sandy said I think I need you.
Oh, yeah.
Oh, we'll go do your call.
No. I'll answer some questions.
So does anybody have questions for our attorney? No, you're fine.
And I know too, because I know Holly does forward some stuff to me. In the bios and all that stuff that you all have, you got my contact information as well. So, I mean, in the future, if you have something that you think is very specific to the statute, to kind of the legal process, anything of that nature, obviously feel free to continue reaching out to Holly and her team. But you can also reach out to me directly. Don't feel like you're obligated to filter through another level. My contact information's in there, so call me or email me at any time.
So we only had 3 questions ahead of time, and one of them is this site to book, if you want to talk about that.
Okay, I'm guessing.
It was, somebody had asked about when someone is, I think it was like an FTA or whatever, which those are, everyone does this differently.
So are we discussing if somebody receives a citation, making sure they have it?
Right, if they're, like, I mean, I kind of mentioned earlier, if the person's not fingerprinted, we're not going to have it. And so that might be like the FTBs, violations of probation. Like a lot of people treat those differently. Some courts say they're charges, some courts say they're not. Sometimes they're booked, sometimes they're not.
Holly?
How does the TBI feel about that?
Well, so I will say, when it comes to citations, whether or not you're booking an individual, how you're handling failures to appear, how you're handling violations of probation. We can tell you what that is, how that is going to impact the criminal history, whether somebody's going to appear or not. I think I have realized after being here from being so I was a district attorney for about 10 years, and there was a whole lot that I realized once I came here that we just had no idea how the actual process works of how things appear on a criminal history. I'm sure some of you have had those conversations with your DAs as well. I mean, it's just not something you learn in law school. It's not something you admittedly talk about at the DA's office. I mean, I always thought when I issued charges on somebody that it just appeared. I didn't really understand or ask questions on how all that worked, right? So I think a decent amount of this with some of these processes, admittedly, especially in some of these counties, we've realized is a little bit of honestly not understanding what we need in order for something to appear on a criminal history. And people are handling things in the courtroom in a certain way just because they just assume it's going to appear. And I know this isn't specifically on here, but a really good example of this that we've realized after being here are charges that are added on to the grand jury. When I worked in a unit where I was indicting cases, we weren't, sometimes they get picked up, like I work child abuse cases. So obviously a lot of those come in on 1 or 2 counts and you add a whole bunch at the grand jury level and then they end up getting convicted of those higher charges, right? So I never knew, I never had, questioned whether or not, I just assumed those charges I added on all would appear obviously on the criminal history at the end, right? I convicted them of it. Well, of course they'll appear. What I didn't know as a DA is that the only charges we have here at the Bureau are those that they were originally arrested on. So we have no way to match those dispositions on all those additional counts. There's nothing to put them to because they were never arrested and booked and fingerprinted on them. it's things like that that I think gets into this broader discussion of, do you need to make sure that somebody gets fingerprinted on a citation? Do you need to make sure they're fingerprinted on a violation of probation? Do you need to do it on a failure to appear? All of those, this underlying issue is the same thing, which is unless they are being fingerprinted, if you send us a disposition on that, there's nothing for it to attach to. It's going to come back into your error files and it's going to live in your, wherever that goes, depending on what system you're using. But long story short, we don't get it. It's never going to appear on their criminal history. So if somebody is not fingerprinted, it could be a rape of a child, but if they're not fingerprinted on it and they get convicted of it, it's never going to appear on their criminal history. Obviously, there's some caveats there where we can go back and assist you with that. But unless something is done, and if it just goes through the normal flow and you send us a judgment sheet, that's why it's coming back on an error message, is because they have to be fingerprinted. We have to have that arrest to attach it to. So I say, let's say, we will not tell you how to handle things at the local level because everybody does do them differently. There's judges all across the state that want to handle things differently. Clerk's offices want to handle things differently because of what works in your county. But what we will tell you is, depending on what process you've decided to use, this is how it's going to impact the criminal history. So I think we can offer that with these questions as they come up, which is, again, bottom line is always, if they're not fingerprinted on it, it's not appearing. We don't get it. So if that makes things more complicated, to make sure that if they didn't show up for booking like they were supposed to, that you got to go back and send them on that citation, make sure they're actually booked. If it's somebody that's getting arrested on a presentment, that's another big one. That we see that again as an ADA. I never realized when I'm charging somebody as a presentment and they just go into the courtroom and show up, we never sent them for booking. We never get those fingerprints. It's things like that that are really important for us at the Bureau, that there's things like today that we're hoping that we can try to communicate that more and educate more, obviously with you all, with the judges, with the DAs, with all those interested parties. So, sorry, that's a very long-winded, I'm not sure if I actually answered the question, but a long-winded explanation of, I think, how we want to handle it.
Especially from your perspective as a former DA. Do we want to talk about the certificate, the expunction certificate?
Do we want to talk about the certificate? Do we want to talk about the certificate? We can talk about the certificate. Oh, yes, we have a question.
Yeah, before we move on, I would like, because from a clerk's perspective, that seems insane that you all can't add the additional charges from the judgment. So will you just explain to us why on your end it has to be tied even if you already have a fingerprint card on a lesser charge and charges are added? Will you just explain to us why that's your process?
So so the arrest belongs to your county, and Deborah, correct me if I'm wrong. So we can't change anything until on your city or county level, you tell us to change it, because it doesn't belong to us. It belongs to the arresting agency. So we have to match what they have. So they have to update their records, and they can send a correction in and we can add them, but it has to come from the arresting agency. Does that make sense?
Well, why can't it come from the court?
Deborah? I think because the arresting agency is who actually makes the arrest, is what my guess is.
Well, I mean, that's the one, yeah, that's the rest of it. That's just my thought as far as legal, Rachel, maybe.
Yeah, so I think there's kind of two reasons why, two separate reasons why. One is because this is all coming in electronically, obviously we get thousands and thousands of dispositions. We don't have somebody at the Bureau that is sitting and looking at every single disposition that comes into, right? I mean, we need all of you to do that.
We have like 80,000.
So obviously it's automated, right? So there's that piece, and that the system literally has nothing to attach that disposition to because there is no offense to attach it to, right? So if they were only arrested on 2 charges and you send us dispositions on those, the system can attach those to that arrest. But there's literally nothing in our system to attach those other dispositions to. It doesn't know where to put them. Like, that's honestly just a practical reason why it doesn't work. And we try to go in and see those when we come across them, maybe for a different reason. I mean, practically, there's no way for it to do that. The other side of that, from kind of a legal and just making sure that records are correct side of that, which is why when you do notify us, there's a process, is if that disposition was ever questioned, we have to be able to show, one, that it's attached to the right person, it's attached to the right arrest and all that. So obviously that's why somebody's fingerprinted at the very beginning. If they ever were to dispute that arrest, which add-on charge is a little bit different, right? Because you do have those others that go to it, but like a presentment's a really good example of that. If they don't have anything in our system at all, we get 4 charges, we don't have an arrest at all to attach it to. We've got to have those fingerprints because we can't even prove the putting it on the right person's criminal history. So that's the other piece, is we've got to be able to prove that we're putting it on the right person's criminal history and that those counts are correct. And so there is a process. We have, our recommendations have always been, you got 2 ways of kind of fixing this issue. One is go have the person fingerprinted. Obviously, if they're in custody, or if we catch it somewhere in the process before it's been disposed of, that's a little bit easier. Somebody's out on probation or they've pled time served. I realize the logistics, they're not going to come back in and get fingerprinted. So we do have a form that can be filled out that is done. We've sent those. I've sent those to a couple ADAs when they've called in and asked questions. There is a form that can be completed. The thing that says that you all will all have once this is over. So there's another way to go about it, but that's kind of the twofold reason why it can't just attach.
When we get those dispositions that aren't, so there's a intensus and most of you are on intensus. So when those come in and there's nothing to match it to, we print those out and send it to the sheriff's office and say, hey, we got this dispo from the court, but we don't have a fingerprint card. Can you send the fingerprint card to us? And Haven, what response did we get from the sheriff's offices?
Typically that they don't have the fingerprints, or there's no fingerprints on file. So
Right.
then we're left with nothing.
I think that's part like that. Thank you. That makes sense.
Yeah.
Like, I think for so many of us, we sent in paper dispositions for so long that I didn't think about it being automated since I know it's automated, but I didn't think about it being automated. So that actually makes really good sense. But are you all talking to sheriff's office and DA's offices about this stuff? Because what you run into is we as the clerk's office discovered this issue a little while back, and we've been able to resolve it in our county, but it's initially met with, that's not my job. That's not my job. That's not, nobody wants to take on the extra work of getting this done, although everybody cares about making sure. Ours happened to be a murder charge that didn't get on this person. That we have somebody walking around with a murder charge that's not on their TBI. And I'm like, why do we care more about this than the DA's office and the sheriff's office?
Yeah, and I will say, we do see that it sees more, a lot of times is entire charges because those are the ones that often go through presentment process. And so those are the ones that we're missing. And obviously that's the deal. Yes, we're trying to get in front of all of the other groups as well. We've handled those same thing piecemeal with the counties as we've seen it and we've been able to address it. But yes, we realize obviously you all are not the gatekeeper of all things and we're not trying to put it all off on you all. You're just the group that happens to be hearing it this morning. So.
Ms. Polly, can you please send that form back out?
Yeah, we'll send it with the post-conference. We're going to send out everybody's slides and the form and a survey that we need you to fill out. Yes, question?
I've got some stuff that I have found. I'm trying to get back on criminal records, but we don't have a fingerprint card or a number to match it to. It's like 15 or 20 years ago. It's not a census, so it wasn't ever entered on census. And when they converted, nothing ever moved over in that box. How do you go about finding that record at that point if it's not on their criminal record? How do you go to find it, to correct it? I've had a couple like that.
So you have record of the disposition and know what they were convicted of, but there's nothing for the arrest. Is that right?
There's nothing for the arrest in your, where you are.
That my sheriff's department that's in our archives.
Right.
I don't know if we can find that or.
So you can reach out to us to see if it actually is, if we actually have the charge, because pre-2000, Deborah, is that when the state control number came into existence, 2000, 2001?
Yes.
So arrests before then are not going to have a state control number. And so those you do need to send in manually if it's an older thing that's being disposed or expunged. But you can check with us to see if we have the arrests.
What was that year again?
It's 2000, 2001. It's before I started doing this. Oh, Susan may know, actually. Do you know when the state control number came into being?
I was just sitting here thinking about that.
It was around,
About 2000 or 2001.
yeah, that's what Deborah and I also believe.
I think 2000, 2002, in those years, yeah.
Any questions in the chat?
I think we have one. If we have someone booked and fingerprinted on it and we report it to TBI without an arrest date, as they weren't arrested, it shows on the TBI error report. But we can't put an arrest date if they were just cited. So how would we do that if they are never fingerprinted, if they are fingerprinted but never arrested?
Lisa? It sounds like a tense discussion.
It's a good question. They're fingerprinted but never arrested.
Yes, but they don't have a.
So they have a booking date,
Citation.
but they,
Can you use the booking date for the arrest? What would TBI want in that situation?
I mean, if we received the arrest, it would have the booking date. Like that's what we
That
come
would
over
be the
to.
date of arrest, right? The booking date would be the date of arrest.
Right,
Fingerprint them, they have to have a date of arrest.
right.
I mean, so I think this is, honestly, I think this may be more of a policy decision of what we want that to look like. That we can actually have, I mean, we can definitely have that conversation. I would say it could be either the booking date or it could be the date of the offense, because that's, I mean, obviously if you were arrested on scene, that would be, that seems to make the most sense to me, that it would be the date of the offense. I mean, I don't know at the end of the day, criminal history, it's gonna make a huge difference which date we choose to pick, as long as something's in that field. So, but my initial gut reaction would just use the same, your date of your offense.
Unless it's something that doesn't need to come to TBI. And then on your, Lisa, make sure I'm right. So on your intensis, you would just not check the box that says send to TBI.
If they were cited and not arrested.
Yes,
Yeah.
and then it will not be on your error report.
Right. But now if you're expecting, if you have a fingerprint number, but they don't have a date, then you're not gonna ever get it for TBI.
Right, I think it would have been rejected by Deborah's unit if there's no arrest date. Like, I don't think you can even do a live scan without a date of
You have
arrest.
to-
So in this scenario, there's a fingerprint, then they would have to have a date. So are you guys matching? What date? Is that what you're,
We would do our best to figure out, and if we didn't know which one it was, we would just reach out to the clerk.
So, sorry, so can I ask a follow-up question to the question in the chat? So is this, am I understanding the question correctly, that the error report is coming back when they're trying to enter the disposition?
Or TBI without an arrest date, if they weren't arrested, and it shows on the TBI error report.
so it will never get to you.
They need to
Right,
enter the
but-
box.
But if they had to have typed in an arrest date in order for it to go through the live scan whenever they were fingerprinted, is there a way for the clerk's office to access that information to know, would that be something that came over to them from the sheriff on the booking? Because right, I mean, it seems like to make things, I mean, what they should do is they just need to use the same date that was used as the arrest date whenever they were fingerprinted at the end for the disposition. So, and this is me not knowing, this is your all shop, knowing the nuances of how all that actually comes over. And maybe this is a question for all of you as well. So if you have somebody that has been cited, they were fingerprinted, do you have access to that information from your sheriff to know what the arrest date was? Like, are they sending you, like they're supposed to, the RA4 to where you have that information? Because if they are, then I would say you just use the same date, obviously, that's on the fingerprint card. But it sounds like that's where it would live, that we don't actually need to come up with a policy on what date to use. That date's already there. It's on the fingerprint card. So I guess that's the long-winded answer is use the same date it's on fingerprint.
We have a question in the back.
Okay. On when an individual is fingerprinted, they get the state transaction number and the agencies sending your all's information to with that state transaction number. As that disposition comes back, isn't it only looking for that state transaction number and not the dates?
And that's how it matches up with the state control number.
Yeah, state control number. So
They are getting an error. It won't come to us without, there's certain information that has to be on there for the disposition, and the arrest date's one of them. And so that's why it's popping back. They're getting an error because they don't have the arrest date.
Yeah, they just need to uncheck the send to TBI button.
Yes, you're getting an error after the disposition. And no arrest date.
So yes, I would say if you want it, you have two options. If you want it to come to TBI, you're gonna have to figure out what that arrest date was on the fingerprint card, because it will have to be there for them to have been fingerprinted.
If
So-
it was cited, we use the offense date and it's never to us.
Does that make things complicated on our end too?
Yeah, I think, yeah. I mean, we have that all the time.
Okay.
So,
then there's three options. Pick the offense date, take the time to go back and look at the fingerprint card, or don't send it to us.
we want that.
They didn't decide it's.
Any other questions in the room before we, yes?
My question is, we're getting a lot of files transferred over to adult court. Are those charges getting reported?
Not unless they are being fingerprinted once they come over to adult court.
Okay.
That is huge, especially for firearm purchasing, now that we have this new state prohibitor, which actually that's a little bit different. I think that's different. But yes, for juveniles, that is a huge issue that we have seen statewide. This is kind of like, it's the same thing as a presentment. Whenever those juveniles are coming over, and they're getting transferred to adult court, they have got to be fingerprinted, or we do not get record of that, because there is a separate statute that says, even if they were fingerprinted in juvenile court, there is a statute that says that those fingerprints that are taken in juvenile court remain at the local level in a separate database. Those do not come to TBI. And so even if they were fingerprinted in your local courts, in juvenile court, and they arrested in juvenile court, we don't have those. If they get indicted as an adult, you have got to have them re-fingerprinted. That's reasonably important. Yes.
Are you still wanting the order of disposition of ones that are transferred? They haven't been adjudicated in our court. We've transferred them to the adult court to be tried as an adult. So are you wanting that order of disposition on those from the juvenile court?
No, so there shouldn't, so you're saying the transfer order. So there shouldn't be a disposition order to be transferred. You're saying, do we want a copy of that transfer order? We don't need a copy of the transfer order for us at TBI. All we need is just for them to be fingerprinted once they're actually sent over.
Do you know who actually does the fingerprinting once they're sent over?
That's going to be up to the court, whether it's your criminal court, circuit court, depending on how you're jurisdiction. But I mean, it's going to be up to that court to send them to be fingerprinted. That's part of the issue. There's no concise process. I mean, it's kind of, again, it's just like any other presentment. They're coming over, they're getting indicted in adult court once they show up on that arraignment date. I mean, that would be my recommendation. I know that's the way I tried to handle it when I was in ADA. If I had a presentment or a juvenile, was asked that they go be fingerprinted on their arraignment date. And obviously, depending on how your courts are set up. In some places that's easy because fingerprinting is right there, and other places it's not. So, but I mean, again, that's also a conversation for the ADAs and for the judges. Is, hey, if you've got these cases when you're doing an arraignment, please kind of have that as middle on your checklist just to go send them to be. Yes.
What if we never get a fingerprint because the defendant doesn't cooperate? And they release them without being fingerprinted?
There's no way for us to have the charges and add it to the criminal history without a fingerprint card.
Yes.
So I work with CTAS. I'm the jail consultant with CTAS. If a juvenile is in juvenile detention and transferred, goes straight from juvenile detention to jail, then those fingerprints, one of the questions asked, those fingerprints should be automatic as part of the standard booking process for those that are in custody.
But they may be booking them locally and not sending it to TBI since it's a juvenile. Right, Deborah?
That is correct. And the ones that we do get for juveniles that we have gotten in the past, are felony arrest only. That is the only juvenile arrest that we get. And of course, now with the changing the laws, as you said, we shouldn't be getting any unless they are going to adult court, correct?
Right. And that may be something that I would check on that, because at least from the Bureau side of things, we're not seeing those, that they're coming over. That may be
I'm not saying those that were fingerprinted in juvenile detention. I'm saying once they come into the adult, once they transfer.
oh, right, they're automatically being booked. Yes.
And they're fingerprinted.
Okay.
Yes. Yeah. Sorry. Yes.
Nobody wants to think about certificates, I guess.
We have any more question? Yeah, we're fine. We have to. Not this.
And I think I got myself confused. So I just want to go back over the fingerprint card, but no date. No arrest date. Does TBI want those if there's a fingerprint card, but they were never arrested? Or does TBI not want those as a fingerprint card and they were not arrested?
Yeah. So I think the answer to that is another one of those where I'm going to put it back to the locals and say, we are the repository of whatever information you want to send us. I mean, I know statutorily there are, and I can pull them, there's a statute as it relates to booking that discusses certain offenses that do not have to be sent, that don't have to be included on a criminal history. There's also some language as it relates to expungements with B and C misdemeanors that don't have to be sent over. And I think it's because we wouldn't necessarily have those on the criminal history. There's very few mentions, honestly, in statute about how to handle those. I mean, really, the statutory guidance is you cite somebody, they're supposed to be booked and fingerprinted. So, I mean, there's not really, it's not like there's a statute that says, hey, you only have to send them to TBI if it's a felony. That language just doesn't exist. So again, I mean, we can have that conversation internally if we want to put out something within our SOPs as far as like a preference of the Bureau. But honestly, I don't know that we have the authority to make a preference of the Bureau because we're the keeper of the records, but we don't get to decide what everybody else gets to see across the state. I feel like that's us overstepping a little bit.
So there is a question in the chat.
Oh, I'm sorry. So you guys, I guess you guys get those if they're fingerprinted, even if they're not arrested.
It's as long as
if they submit it to TBI. Yeah, because they can be fingerprinted as local where it just stays with them, or they can submit it where it goes to TBI.
Correct. They just fingerprint them and they say local, it is staying at the agency's live scan. It is not going to TBI.
Okay, so you might.
So they can cite and fingerprint someone's, but not submit it to TBI.
Okay, good. Okay, thank you.
And again, I know there's counties that handle this differently because there's counties that send the fingerprint on everything, send it all to the Bureau, and then we end up actually getting questions on expungements because there's some offenses that can't be, like driving charges, that there's really no expungement mechanism for them under the law, but we've got the fingerprints. Like there's some things that do, again, I think everybody handles it differently, so I don't know that we're really the appropriate decide what you choose at the local level to be on somebody's criminal.
The question in the chat.
We did answer it, but she asked, you're saying that the juvenile sent to circuit needs to go get fingerprinted for a control number.
Yes. So, and yes, to clarify, and sorry, now that I understand the point that was being made in the back, and I apologize. These are going to be individuals, obviously, that are out of custody. And most, I mean, a lot of the juveniles are. But right. So if they are out of custody, even when they were originally taken into juvenile detention, if they were fingerprinted as juvenile, if they were out of custody and that case comes to criminal court, it's going to be just like a presentment on any other adult. They have not been fingerprinted in that criminal adult system. Therefore, we have to have them fingerprinted.
I have another question. She says, so can we put the offense date under the arrest date if they weren't arrested? You could use the offense.
Yes. But if they were fingerprinted, we consider that an arrest. So I've always said I need court lessons. Yes, ma'am.
Okay, so this might have already been asked, but okay. So if a person is cited, I know they can have like a local sick control or like talking about like the local.
Yeah, if they print as local, we'll never get it.
Okay.
You don't see
So
it.
when we go and put a site in Flex Check, why? Because y'all don't have any record of that, right?
So we're gonna process anything you send us.
Okay.
Especially if the person had a diversion, we need to know that because they can only have one. So we need to have that on our records.
Okay.
So anything that you send us, unless you send us like a, the order of protection, we can't expunge those because it's civil. So we don't have that on our records, but we would have a violation of order of protection. So that's pretty much one of the only things we're gonna reject back, right? Yeah. Did that answer you? Yeah, let's talk about the certificate.
Okay, so hopefully everybody is familiar with the expungement certificate. Took our training that we did about a year ago and using Flex Check and everything's working perfectly. But on the off chance that that's not the case where you are, really quickly, so 2023 legislative session, the General Assembly decided to add in language into the expungement statute. They created an expungement certificate. They pulled a little bit of the language from the diversion certificate that basically says if prior to an expungement order being signed, so same language with diversion, prior to the expungement order being signed, basically the judge is not supposed to send in an expungement order now that does not have this certificate attached to it, with the exception of dismissals.
No true bill.
Yeah, there's another, I'm sorry, my brain's not working, but basically, if it is a conviction expungement, if it is a pardon, if it is a diversion, we need those on diversions. I know some people, because it's a dismissal, they think we don't need them on diversions. We absolutely need them on diversions. That is not excluded. So a diversion, a conviction, a human trafficking, a pardon.
We count the two diversions differently. That's part of the 5, the judicial and a pretrial. That's what makes up our 5.
Okay. Yeah, that's weird. Okay. Yeah, so on those, we have to have an expungement certificate. The reason is, and this actually goes back to a case where we were sued on, and it is a individual who had a sexual offense diverted. There was a judge who allowed an expungement of that sexual offense. Obviously, under the expungement statute, you cannot have those expunged, even if you go on diversion. That is a conversation I still have with defense attorneys and ADAs on a daily basis. And so what happened in that case is we denied it. We denied the expungement we had for years and years and years because we knew statutorily you could not have that offense expunged. Long story short, the Supreme Court said, TBI, you don't have the decision to make, you don't have the authority to make that decision. If you receive a court order that has been lawfully signed by a judge, you have to follow it, even if they're not following the law. Regardless how we feel about the rationale of that decision, that is the current decision. And so to try to assist courts with that, to make sure that we did not end up in that situation again, the General Assembly created this certificate. That we all are getting used to. And so the way that the certificate works is your judge, somebody, however it works in your county, whether it's the individual coming to you on a G expungement, time to the DA, however that works, you should be going into Flex Check and entering whatever it is they're trying to get expunged. Again, if it's a standard dismissal, things like that, we don't need it because and the reason is you're trying to think through it. Anything that you know, everything in that category is eligible for expungement, which is why we don't need them on dismissals, right? Because there's nothing that's precluded that can't be expunged and dismissed.
So
we don't need the certificate.
My cheat is if it's not in the drop down, we don't need the certificate. If it's in the drop down, we need the certificate.
So that makes sense to all of you.
In Flex Check, yeah. Or you can pick the expungement.
But if it is one where there is a potential that something could not be expunged, you have to send it twice. But it is like the diversion certificate and that we're going to tell you it's eligible or not. a judge can look at that and say, well, I now realize the sexual offense can't be expunged, but that was the agreement at the time when we signed the diversion. And so I'm going to sign the order anyway, even though it has the certificate attached that says not eligible. For our purposes, that is fine. That is up to the court to make that decision, and we will process it, because in light of that court decision, if we receive an expungement order that is signed by a judge, we have to honor it. So the certificate is really there. That is also why it is supposed to be done before the order is actually signed, so that the court maybe has that forewarning if they did not know, to say, oh, oops, I was about to sign an expungement order. And that's the whole reason it's there, is to assist the court so that they know if, for whatever reason, they didn't go back and review the statute where they signed the order. It's to help them so that they know before they expunge something that they shouldn't. That's really high level basics of how all that works.
So recently we had a question.
Okay.
Why do we need the expunction, why do we need the diversion application if we're going to do the expunction certificate?
Because those are very different, right? There are, so this is where it gets really complicated. So the diversions, in the diversion statute, if you've ever had any reason to look at it, inside the diversion statute, it defines what is a sexual offense, but only for the purposes of diversion. So it has what we all know for these broader scheme of sexual offenses. It's a much smaller list. You cannot go on diversion if your charge is one of the listed sexual offenses under that list on diversion. However, also within that diversion statute, it also says, just FYI, if you are going on diversion, which you're allowed to under the statute, for any offense that's listed as a sexual offense on the sex offender registry, so 4039-202, if you go on diversion like you're allowed to, so we would mark you eligible for diversion. If you go on diversion for any of these offenses, stat rate's a really good example, then, or sexual battery, any of those are the ones we probably see more often. If you go on diversion for any of these, hey, FYI, you can't have it expunged at the end. It's in the diversion statute. That exact same language is also in the expungement statute. For some reason, attorneys across the board, across the state, overlook that language every day. So that is why you need both, because you can absolutely go on diversion for some offenses that are sexual for purposes of the Sex Offender Registry Act, even though they are not prohibited under the diversion statute. So we will say, yes, you're eligible for diversion, but when you come in on the back end for an expungement, they may be ineligible for expunction. Everybody thoroughly confused? Because it is confusing. But
Ineligible, you'll still accept it if it judge.
because we have no right under that court opinion.
TCA code for that.
I'm sorry.
What's the TCA code for the sexual? Because we're getting lots of diversions on sexual.
So for which offenses can't be expunged, it's within 4039-202. That's the definition of sexual offenses and violent offenses. So that's going to give you a list of all of those that require registry. If it's the easy way is if it's an offense that requires going on the sex offender registry, you can have it expunged. But that's where all those live. Those are all the.
Question is, a guilty plea that is being expunged, the certificate has to be submitted.
So it's a conviction expunction? Yes, all of those have to come to us.
And then another question, an issue that I'm running into with certificates is the expungement orders are being signed by ADAs and judges without a certificate being attached. Any advice?
I'm not legal counsel for your local judges and attorneys. It's one of those that I will, I will say, again, I don't have any advice, but I will say that because the statute requires those certificates on there now, it also, I will tell you, because I was in these conversations with the General Assembly, I know a little bit of the legislative intent behind that, is that now the judges know. And so if they're not following that statutory guidance as they're required to, if you sign something that then becomes an issue later down the road because that individual maybe does something later, or law enforcement is not aware of a particular arrest and they're able, maybe purchase a firearm or something of that nature. It's not gonna come back on us. The easy answer.
We got another one. It says, what if an expungement order is submitted by a judge for an order of protection? It was said that they cannot be expunged due to being civil, but what if we have a signed order from the judge?
Yeah, so that is one honestly that I've kind of got, as admittedly, I think that's a question I still have flagged in my email because I'm trying to come up with the correct way to deal with that. That's gonna be ones that I'm gonna say, let me flag that and we'll respond back to the group. I'll just, because we've gotten that several times. I mean, I know right now our process is we say,
We reject it.
because it is civil, you can't expungement. Now, if we're getting an order that just says remove this from the criminal history on something that's civil, that's completely separate from relying on the expungement statute, I think that's different.
Like the support and support. Those are usually, but they get fingerprinted sometimes.
Yeah, that honestly, I think is more of an NCIC question that I just need to dig into a little bit more. So all I say, I don't have an answer for that right now, but I'll get you an answer.
But if it's submitted, our process is to reject it back and say that we can't process it because we don't have fingerprints to go with it. Questions in the chat?
Is there a TCA code that says that the Supreme Court trumped like the judge's signature?
So talking about the court case, so that there's not a statute. So that is more, that gets back to all of your civic lessons in high school. That is a separation of power argument. So the General Assembly cannot now, because of separation of powers, our General Assembly, in light of that court decision, could not go in and statutorily just say TBI has the authority to deny it. It would have been deemed, the courts would then come back and said, you can't do that because you're stepping on our toes. It's the whole, we've made this decision. We have the authority to make this decision. So you can't come in and trump what labs do kind of thing.
Nope. The question.
So we've had a couple of cases here recently where they have a sex offense that they've led to, and they have been put on the sex offender registry for like 6 or 10 years. Does that expungement situation still apply to where they cannot get their case expunged?
So we have a presentation by the Sex Offender Registry. I think they're coming up next.
Well, but I can answer that. Okay. I can, sorry, ask the question one more time because I thought it was going to just.
So if someone has a sex crime that is on the list that cannot be expunged, but they are only placed on the sex offender registry for like 6 or 10 years, because we're seeing that more often now, can that be expunged after that 6 or 10 year?
So is it a diversion or is it a conviction?
It's a diversion.
No, it cannot. So the way that both the diversion statute and the expungement statute are written is just if it is a sexual offense as defined in 4039-202, which are all of those that are eligible to come off after 10 years, specifically says if it is one of those, it cannot be expunged. Yep.
Are we gonna go over the handgun?
Yes.
Thing?
That they will be, the 6 unit and Department of State will be presenting at 11. You save all those questions for them. Any other questions?
In the chat.
Oh.
Version is completed. The charge is technically then dismissed. Dismissed charges are expungable. Will they still come back as ineligible?
Yes, so I understand that, yes, so this has been a question with this certificate as well. Just the quick answer is diversions are treated differently than dismissals under A. And if you look at the language of how they worded the certificate language at the bottom of the statute, they didn't say dismissals. They specifically referenced A1, which is where it then talks about cases that are no true build, are dismissed, are released without charge. And so diversions are discussed separately A and C, don't hold me to that, but the way that the expungement certificate language is worded, it cites to the specific sections of the statute that do not require the certificate. I think that's been a lot of the confusion because when we talk about it, we say dismissals aren't needed, the diversions are. If you look at the statute, it is very clear from the statute that we have to have the certificate on a diversion. And again, diversions are treated differently. If you look at the statute, they're in a separate category, they're in a separate section, they are discussed differently than your other traditional dismissals.
So you can send an update for the disposition to us to say that the diversion has been completed and dismissed in that date, but that's what the disposition would say. It would still be a diversion. It would just say that it was dismissed.
And so that's the thing kind of with these expungements on diversions as well on these sexual offenses. They can still, the disposition will still show dismissed. It will still show that that the case has been disposed of. You just can't ever have it expunged. And that is a legislative intent that goes back to the whole risk of reoffending with sexual offenders. And they want to make sure that law enforcement has access to those records. So they don't want to be expunged.
Which when they made us remove all of those charges because of that Supreme Court ruling, we already had reoffenders. Like their record was expunged and then they reoffended and now they have charges again. Hopefully they'll stay this time. Any other questions? Oh, yes, ma'am.
Non-presenters. I don't know if anyone else is having trouble with them, but like I feel someone who gets their case is not presented to the grand jury. I kind of want to treat it as a dismissal for them to be able to get it expunged. But there's nothing other than it just says it's not going to be presented.
Yeah, so it's not a no true bill. It's just one the DA's office did not take.
Correct.
Yeah, so that's another one that we've dealt with several counties. Because I agree, I think those are stuck in limbo land.
Yes.
Right, that they just live
And
there.
that's what our DA's office says.
Yes. Now, technically, a defendant can file a speedy trial motion on anything that is pending in grand jury. And if the DA's office chooses not to indict it, the court will dismiss it. I think that is a workaround, but that is I'm coming from the DA's side to say that's a workaround. From us at the Bureau, I think we would need to maybe think of if there is an alternative process that we would feel comfortable maybe getting some kind of an order in order to show that something has been dismissed, right? That in lieu of, and honestly, that may be something that is affixed in the expungement statute too. I don't know. I'd have to look at it. I don't know if that's something that we would even feel comfortable doing without statutory guidance to tell us, because we don't like removing anything from a criminal history without having the legal authority to do it. So I think the option right now is those individuals, you've got something from a criminal court judge showing that the case has been dismissed. Which again, I know there's a legal pathway to do it, because if an individual files a speedy trial motion and says, hey, which most of the time happens to people, they're sitting in custody, right? They're sitting in custody on something and they want to know why they haven't been indicted. But anybody can file those. So knowing that the avenue is there, I mean, if I had an ADA that called me and said, hey, what do we do with this? My guidance would be you take your case in front of a judge and say, hey, we're not presenting this. Please have a dismissal order. Because at that point, so the General Sessions Court, as you all I'm sure know, they have lost, that's the other issue, is General Sessions has lost jurisdiction as soon as it pops out, as soon as it's found over, right? So the General Sessions Court now can't do anything with it. That's why it's stuck in limbo land.
Yeah.
And so that's why at that point, it technically is the criminal circuit court that now has jurisdiction. That's why the speedy trial motions go there, not General Session. So again, this is me more speaking just from an attorney than a bureau representative, but I would say that's the way to handle it, is it's got to be a motion that's signed by your judge in criminal court that's dismissing it. Because I don't think that there is an avenue currently within the expungement statute that addresses that situation separately.
What we've been doing is the DA will return it back to General Sessions and General Sessions will dismiss it. So that's wrong.
I mean, technically, the way that the laws are written, they don't have jurisdiction anymore. But again, it's one of those, sometimes local courts do what is easiest for the local court, and as long as they make complaints, it's just, but yeah, I mean, technically, technically they don't have jurisdiction, just the statutes are written, but I'm not gonna tell you to go back and tell your judges to stop. Can't let it that way.
So we've got 2 more minutes.
What if our DA does a remand dismiss? They take what I
And they
call,
remand it back.
they remand it back to.
Yeah, I mean,
Present it. Is that okay?
yeah, and again, this is me speaking of just, I guess, an attorney that is familiar with the way that the criminal justice process works, not necessarily the TBI attorney. But yes, you can absolutely remand cases back down. Now, technically, there's reasons in the statute you're allowed to do that, but.
Which judge signs the order?
Right, and that's where it also goes back to, so this is me speaking as a TBI attorney, if we get an order from a judge that has been signed, we're accepting it, we're not gonna challenge that, so. It's not gonna matter if it's signed by a general sessions court that didn't have jurisdiction, we're not questioning that.
But you have to have that signed order as well with the expungement.
We just need an expungement order. We just need
One more question over here.
So if we have a warrant from general sessions, it was bound over to the grand jury, but they were indicted, but just not on a specific warrant from general sessions. Do we need an order dismissal on that one charge?
she's saying so let's say they were arrested on a theft and they end up only get indicted on a burglary. Is that what you're saying? Like that original charge is not indicted at all. It's something totally separate. How do y'all handle that?
So okay. Walk me through that one again.
So if they had 2 charges in general sessions to go through grand jury, they were only indicted on one of the charges.
Okay, yeah, we just need a dismissal expungement for the other one if it was dismissed. Which that would be a partial, since it's part of the same arrest.
So the circuit court judge should, or the DA should give us an order of dismissal on that particular charge.
Right, which would be a partial expungement. Okay. And we didn't even touch on that. Okay, so it's break time. So if everyone will be back here at 10 o'clock. I don't want to. So we're going to start back at 10 o'clock.